Because, my lord, the AG has relied on those three decisions.
Very well. অর্পণ মনে করে এটা দুপুরবেলা দুপুরবেলা আসবে আমার কাছে।
I'm deeply obliged, Lordship.
May I be permitted on mention on bill matter?
Inclusion, give it. Inclusion, we said just give it.
Inclusion or interest?
রাখো।
Order number 1.
Here is the direction matter. This is the report matter.
Where is the petitioner?
Petitioner not required matter. The
Oh.
bail application matter already disposed of.
Oh,
There was a direction again upon the matter investigating officer matter. Let kindly see the report matter.
হ্যাঁ, ফাইলটা লাগবে।
Against the investigating
এটাও খারাপ
officer
হয়ে
matter.
সিস্টেমটাও খারাপ হয়ে গেছে, বুঝেছো?
Against the investigating officer matter, proceeding.
Sir, we need to see the last order. Kindly wait, ফাইলটা নেই।
Item 1.
No, matter is not disposed of.
Bail application matter already disposed of.
By order dated?
I have after my lord dispose of my lord matter appeared up 3 times my lord for report my lord.
Yes, yes.
Matter disposed of.
19th February.
My lord, para 7 and 8 my lord explanation my lord.
We'll send this matter to Justice Bagchi. That is the best, because what his lordship had in mind, we do not know. Esho. A report has been filed by the Commissioner of Police, Chandannagar Police Commissionerate, in court today, pursuant to the order dated March 28, 2024, passed by a coordinate bench. Stop. Let the report be kept with the records. Paragraph. Since the report was called for by the other bench, we feel that it will be appropriate that this matter be placed before this matter be considered by that bench, placed before now. Stop. Paragraph hence, let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction. Assignment will be required.
Yes.
Because today that bench has no determination.
28 রিপোর্টটা চেয়েছি কিন্তু 19 জুয়েল
Order number 2.
Madam, for the petitioner.
আমার ফোন করেছিল তো। Yes, commercial quantity.
Madam, for the petitioner. My lord, in connection with the present case, petitioners were arrested in connection with 399-402 case. Thereafter, they have been granted bail. In the meantime, they were tagged in connection with the NDPS case. Nothing recovered. They are in
One
custody.
co-accused was arrested with 82 grams of brown sugar. He had implicated these two petitioners as his companions, but no recovery was made from them. But they were arrested in another case, 399-402, and they have been shown arrested in this case. Investigation is going on.
97 days in custody, my lord. Nothing recovered. Recovered from one other co-accused, PC person, Chaitanya Mundal.
That is commercial quantity.
That is commercial quantity, but nothing recovered from these petitioners.
So he was in the custody at that point of time. When the at that point of time he was in custody. Then how can it be possible?
Well, yes, but he has the arrested person as written. They also work with him.
No, that's all right.
That is only.
Issue. Commercial quantity of contraband items was seized from a co-accused of the petitioners. Stop. The petitioners at that time were in jail in connection with another case. Stop. Nothing was recovered from the petitioners. Stop. On the
No, my lord. What has happened is that the person FIR in this case lodged on 24th of February. The other case is of 19th of February, but these two petitioners were arrested on 6th of March.
oh, I see.
They were arrested
Very well.
subsequently
You will
Shown arrest.
in this case.
Shown arrest.
না ওটা কেটে দাও ওই সেন্টেন্সটা কেটে দাও তারপরে কি বলেছি ওটা ওই nothing was recovered from the petitioners. Stop. They have been implicated on the basis of statement made by the co-accused. Stop. Paragraph. Since there was no recovery from the petitioner, petitioners, the restriction in section 37 of the NDPS Act may not apply. Stop. Paragraph. On an overall consideration of the facts and circumstances of the case and the material in the case diary, and considering the possible extent of complicity of the petitioners in the alleged offence under the NDPS Act, we are inclined to grant bail to the petitioners. Stop. Accordingly, 25,000
And he shall meet the IO once in a week. Until further.
once in a week. এটা বোধহয় once in fortnight আছে অন্যটা, এটা once in a week করে দিন। আর 25,000 each, দুজন আছে।
Record on.
Order number 3.
I think they are not pressing this application.
Not pressing. Learned advocate for the petitioner says that he has instructions to not press this application. Paragraph. CRM such and such is dismissed.
Order number 4.
I don't know, formal, we are. Well, I am for the petitioner.
ঠিক আছে তাহলে আমি হ্যাঁ ঠিক আছে হ্যাঁ একদম
Ma'am, for the petition.
Yes.
And this is the first application. The petition is in custody for 2 years, 6 months.
What is the recovery?
Ma'am,
Where is there, Malad? 24 kgs of 24 kgs of gaja.
24 kg.
Gaja,
500 milligram
gaja, commercial is 15 kilo, above 15 kilo.
Another co-accused was granted bail, madam, page 31. But I am claiming parity, madam. Last occasion, madam, kindly see page 31, 18th January.
No, Caesar list does not name you.
Yes, for both,
No,
both the name.
there is naming, but he is claiming parity.
Standing
Page
on the same
31.
footing.
Yes, madam.
Standing on the same, page number
31
31.
of my application.
I see. This is for the delay, on the
Yes,
ground
sir.
of delay.
Here is the main reason, but Malad, the seizure list speaks that Malad, he was very much there with the exclusive possession.
He is standing on the same
Same
footing.
footing,
Yes,
same footing. Issue. Issue. The petitioner
9th July is the date fixed for next sitting.
He will appear, otherwise his value.
Yes. Malad. Kindly assure Malad that
The petitioner is one of the accused persons in in this case initiated under the provisions of the NDPS Act. Stop. He says that he has been in custody for
2 years, 6 months.
2 years and 6 months. Stop. There is no substantial progress in the trial. Stop. He cites in an order dated January 18, 2024, passed by a coordinate bench in CRM bracket NDPS number 96 of 2024 and 24, whereby a co-accused was granted bail. Stop. He says that he stands on the same footing as that person and accordingly claims parity. Paragraph. Learned advocate for the state says that this petitioner's name appears in the Caesar list. Stop. However, the person, the co-accused who was granted bail is also mentioned in the Caesar list. And it is correct that that person and this petitioner stand on the same footing. Stop. Paragraph. We find that the coordinate bench granted bail to the co-accused person primarily on the ground of inordinate delay in the progress of the trial. Stop. We accordingly allow this application on the following terms and conditions. করে এই পেজ 32 থেকে যা টার্ম দিয়েছিল আগেরটা
10,000 টাকা with two securities.
এটা দিয়ে দেবে।
both the securities should be local.
Yes,
Is
yes,
it
same
local
share.
বলেছে both?
One.
Whatever the term
Same
was,
condition.
same condition.
One of them must be local.
One of them will be local. Yes, same condition. Yeah. ঝামেলা রয়েছে।
Yes.
5,
Time for the petitioner.
Yeah, for the state law.
And I am for the
Yes.
And I am for the petitioner, my lord. I am in custody for 2 years, 4 months, my lord. Coordinate bench has enlarged on bail the co-accused. Order is at page 10, my lord.
Lordship, earlier this petitioner's bail was turned down in November 2023. Trial is going on, Lordship. PW1 was already examined. Next date is on 13th of June, Lordship. And 199 bottles of fencyl syrup containing codeine was
All accepted. We will all accepted. What about the delay in the trial?
there is some delay.
Saddam Hussein was granted bail on 7th of May. He stands on the same footing as the petitioner. That is the end of the matter.
And anything was recovered from him?
Yes, Lordship,
Joint possession.
from joint possession,
Right.
199 bottles of.
Issue.
No, no.
This is the season list.
কিন্তু ওর কাছে কোনো ওর পজিশন থেকে কিছু পাওয়া গেছিল না। দেখো তো ওখানটা কি লিখছে? You are referring 27/9/2022?
At page 10, my lord. 7th of May, my lord.
ঠিক আছে।
The petitioner claims parity. Stop. He says that allegedly commercial quantity of contraband items was recovered from him and a co-accused person. Stop. The co-accused person has been granted bail by a coordinate bench by an order dated May 7, 2024, passed in CRM bracket NDPS bracket close 780 of 2024, primarily on the ground that a case of breach of fundamental right to speedy trial has been made out. In other words, on the ground of inordinate delay in progress of trial, bail was granted, opining that in such cases, Section 37 of the NDPS Act would not stand in the way. Stop. Paragraph. Learned advocate for the state says that admittedly commercial quantity of contraband was recovered from the joint possession of the petitioner and the co-accused person. Stop. Trial is progressing. Stop. The prayer for bail should not be allowed. Paragraph. We see that the petitioner and the co-accused who was granted bail as aforesaid, stand on the same footing. Stop. Accordingly, the petitioner is entitled to claim parity. Paragraph. Accordingly. Same condition.
5 নম্বর প্যারাগ্রাফটা আগেরটা দেখে 5 নম্বর প্যারাগ্রাফটাও কিন্তু করেছে।
ওই কন্ডিশন আছে, তারপর লাস্ট প্যারাগ্রাফ আছে, যদি অ্যাপিয়ার করতে ফেল করে তাহলে
লাস্ট প্যারাগ্রাফটা লিখে
Obligation.
Order number 6.
My lord, I am for petitioner, my lord. My lord, allegation under section 21C 29 of the NDPS Act, lordship. I am in custody for 2 years, 6 days, lordship. Number of witnesses is 18, lordship. Out of the 11 only has been examined, lordship. Lordship, 73 bottles of fentanyl was recovered from 2 persons, lordship.
So what is the nature of evidence?
My lord, from joint position,
From the
73 bottle fentanyl.
Identified.
My lord, this is the NDPS case, my lord, that from joint position, 73 bottle NDPS fentanyl bottle has been
There are
recovered.
incriminating evidences against the accused or not?
Yes, my lord, the Caesar list is there, my lord, and my lord, the raiding party also in their 161 statement, my lord, they have stated that.
The list was proved.
My lord, that the trial, my lord, it has been exhibited, my lord.
11
witnesses, my lord. The
evidence means that has been
yes, my lord. Yes,
then
my lord.
Lordship, if your lordship then ask me, then I can bring the all the evidences, copy of evidences, lordship.
why you have not brought today?
Lordship, I have annexed the order sheets, but not the copy of the
My
evidence.
lord,
lordship.
may I submit one thing, my lord? Yes.
time period দিয়ে
Yes.
My lord, may I submit one thing, my lord? On 16th of November 2023, this honorable court, my lord, passed an order.
Madam, the other cases, the previous 2 cases where we allowed on the ground of parity, there the trial had not progressed substantially.
Yes.
I am also in custody for 2 years, lordship.
But now the trial has progressed.
Yes.
We'll stipulate a time period now.
Yes, my lord, this, as per the direction of this honorable court only, my lord. This is 16th of November 2023. One revision application moved before this honorable court, that is CRA 3195 of 2023. Here, Honorable Justice Tirthankar Ghosh, my lord, specifically directed that trial should be conduct as expeditious as possible. My lord, thereafter, my lord, out of 18, 11 witnesses till date, my lord, has been examined. And charge has already been framed.
4 months, within 4 months.
My lord, my
months.
lord.
Issue now.
Otherwise, we shall grant bail.
Yes. We will say so. If within 4 months it is not, you can renew your prayer.
Lordship, yeah.
The petitioner says that he is in custody for
2 years.
6 days.
2 years, 6 days.
about 2 years. Stop. The trial is still continuing. Stop. Because of the inordinate delay in conclusion of the trial, comma, he should be enlarged on bail. Paragraph, learned advocate for the state says that a revisional application had been filed by the petitioner, criminal revisional
Yes, my lord.
application,
My lord, may I-
being
TRN number?
CRM such and such, near. Write it down and give it.
My lord.
Stop. That application was disposed of by a learned judge of this court by an order dated.
My lord, order dated, my lord, on 16th of November 2023. He has been communicated to the lower court, but the order.
Either you know or you don't know, sir. Tell us.
My lord, my lord,
Can you find out and give it?
my lord, server copy I can.
Order dated blank,
Yes, my lord.
whereby, comma, inter alia, comma, the learned trial court was requested to expedite the trial. Stop. Learned advocate says that 11 out of 18
Yes.
witnesses have already been examined. Stop. Therefore, comma, trial has progressed considerably. Paragraph. Considering the facts and circumstances of the case, comma, we find that this is not a case where the trial has not progressed at all. Stop. There has been substantial progress. Stop. Hence, comma, after considering the material on record, comma, we are not inclined to enlarge the petitioner on bail at this stage. Stop. We request the learned trial court to conclude the trial as soon as possible, but definitely within a period of 4 months.
Excluding the
Excluding? 4 months from the date of communication of this order to the learned trial judge, comma, excluding the puja vacations. Stop. In the event, paragraph corrector. In the event the trial is not concluded within the aforesaid time period, comma, the petitioner will be entitled to renew his prayer for bail.
Grateful, Lordship.
Disposed of.
অর্ডার ডেটটাও লেখা আছে, সিআরআর নাম্বারটাও লেখা আছে। টাইম নেব, টাইম নেব।
7,
My name for the petitioner.
But
Yes.
7 million I'm praying for not today only because develop.
Thursday.
eight,
Wait, please, your lordship. I am for the petitioner. My lord, I am in custody for 1 year, 8 months and 23 days. Nothing has been recovered from me. I am arrested from the statement of the client.
My lord, he is the registered owner of the Scorpio vehicle where from 102 kgs of gaja was recovered.
My lord, I rent out my car. My lord,
To a gaja dealer.
how will I know what?
But my lord, so far as this,
Every owner says the same thing. Yeah, hearing this type of plea side of the owner.
this is the my lord document specifying his name to be the owner of the vehicle. And my lord, trial is in progress, my lord. Charge has been framed. Out of the 12 witnesses, 1 completed. The second cross-examination is going on next day, 26th of
How
June.
many witnesses?
12,
12.
yes.
No witness has been examined.
One completed, the second one, examination in chief done, cross-examination, date fixed 26th of June.
Good.
1 year, 8 months.
What is the antecedent of this?
So far as the petitioner, my lord, in course of investigation, we have not found any criminal antecedents. But huge quantity of contraband, my lord, from this.
How much?
102 kgs of ganja.
Trial has started, sir. We will frame a time period. If it is not concluded, renew your prayer.
Very good.
Issue. Right. Including the official vacation.
Right.
The petitioner says that he is in custody for about 1 year and 8 months. Stop. There was no recovery from him. Stop. Recovery was from a motor car which is registered in his name. Stop. He had rented out the car as he does in usual course of business. Stop. He had no idea that the person renting the car would use the vehicle for transporting contraband items. Stop. Paragraph. Learned advocate for the state produces the case diary for our perusal. Stop. He submits that 102 kgs of ganja was recovered from the vehicle, of which the petitioner is admittedly the owner. Stop. It is difficult to believe that the petitioner has no truck with the illegal transportation of contraband items. Stop. Since commercial quantity of ganja is involved, bail should not be granted. Paragraph. We find that the trial has started. Stop. The second witness out of 12 witnesses is being examined. Stop. On an overall consideration of the facts and circumstances of the case and the material on record, we are of the opinion that this is not a fit case where we should enlarge the petitioner on bail, at this stage. Stop. However, paragraph. However, since the petitioner has been in custody for an appreciable length of time, we request the learned trial court to conclude the trial within 6 months. Within a period of 6 months from the date of communication of this order, excluding the official vacations. Stop. If the trial is not concluded within the aforesaid time period, the petitioner may renew his prayer for bail. Disposed of.
Nine,
Madam, for the state.
My lord, I am for the petitioner, my lord. My lord, allegation under section 21C29 of the NDPS Act, lordship.
Yes.
625 bottles of fencidil, lordship. Lordship, I am in custody for 2 years, 19 days, lordship. Charge has not yet been framed, lordship. Lordship, I have applied before the Honorable Supreme Court when my prayer was refused. But, lordship, there was a direction that the charge should be framed within 4 months, lordship. That order has been communicated to the learned court below.
Where is the Supreme Court
Yes,
order?
lordship. I have annexed
Page?
last paragraph.
This is 19th October. Yes?
And lordship, I have communicated last paragraph of the paragraph 5.
No, we are not on that, madam. 19th October, Honorable Supreme Court's order. Now, your last rejection was on 26th April. Oh, that was 23.
Lordship,
That was
lordship,
23.
and I have communicated, but it within 4 months, 4 months has been passed, lordship.
Petitioner before your
The charge has not been framed, Lordship, and I am in custody for 2 years, 19 days, Lordship.
charge could not be framed because there are other co-accused also. Co-accused are at large, my lord. WP has been already issued against them, my lord. And this petitioner before your lordship, my lord, there is a only recovery from him that 625 pounds.
So you have to split up the records.
Well, we are on the verge of it, so stipulated time may be given, my lord, so that
They are armed with the order of the Honorable Supreme Court.
The 19th of October
I-
last
I-
year,
I've seen
Supreme
the
Court said 4 months.
I've seen the.
And you are saying today we are on the verge of it. কি করবে? Now, for how long you have been in custody now?
2 years, 19 days.
2 years, more than 2 years. কোনো ঠিকই তো কিছু চার্জ ফ্রেমড হয়।
In spite of order of Honorable Supreme Court.
Sorry, this has to, Article 21 is still there.
From that, why
What is this?
the officer did not care about the.
You are sole accused,
No, Lordship, there are
One more accused is there,
2 accused persons.
yes, Lordship.
Lekho.
but the recovery was only from him. The before
Teaser list mentions only him.
only him, 625 pounds.
The petitioner is one of 2 accused persons. Stop. The allegation is that 625 bottles of fentanyl syrup containing codeine phosphate, were recovered from this petitioner. Stop. That is commercial quantity of contraband. Stop. Paragraph. The petitioner says that he is in custody for more than 2 years. Stop. He had approached Honorable Supreme Court for bail. Stop. By an order dated October 19, 2023. The Honorable Supreme Court passed the following direction, page 9. Page 9, bracketed portion. Paragraph. The aforesaid order of the Honorable Apex Court was communicated to the learned trial court. Stop. However, still charge has not been framed. Stop. Paragraph. Learned advocate for the state says that why you could not frame charge, sir?
Because 3 more accused are there. 1 has been arrested, 2 are at large, my lord.
Says that
He has already been issued.
charge could not be framed as 2 other accused persons are absconding. Stop.
Only one indulgence, my lord. My lord, order number 25, page 24, which is annexed in your petition. He has communicated the order of the Supreme Court before the learned court below on 4/1/2020. So after the communication to the lower court, my lord, 4 months it will take, my lord. It is only just on the verge of it.
No, the
She had
period-
communicated the order on 4/1/2024.
Period has expired.
That
4
order,
months has expired.
as per her submission, my lord, she has communicated this order of the lower court. My lord, kindly comes to page 24 once. Order number 25.
Yes,
What is the name of the your petitioner?
Saddam.
Saddam.
He is a habitual.
Yes,
No,
there are criminal
I
actions.
thought that.
no, maybe Lordship, the other Saddam. I am not only one Saddam, Lordship. Maybe, Lordship, I don't know. But I am not only one Saddam. Saddam may be many person.
Maybe person, but this is my
I don't know.
whether that Saddam and your Saddam is same and one.
Not Iraqi.
No, Lordship, I am from West Bengal. I am not Iraqi.
Habitual also.
কি বলো কি করব?
24, page number 24, you are referring?
Page number 24, the order number 25 must. Well, kindly see the order number 25 and then the order number 26, my lord.
it is 4 months was
Then-
given
then
and
my
it is
lord-
6 months is running.
Then my lord sees order number 26. Order number 26, kindly see. There was a local bar. Then order number 27, kindly see. Kindly see order number 27.
Lordship,
The-
where is
see-
my fault, Lordship? What will I do?
Hold, my lord. Kindly see the order number 27.
And Lordship,
It's not his fault.
The learned court below has taken precautionary measures to frame the charge. Kindly see the order number 27. The IC was personally called to take steps in regarding to the arrest of the petitioner, other co-accused. My lord, those are at large. My lord.
Now, what about 7/2/2024? How is the order?
Order number
7/2/24.
7-2. Yes, page number 26.
Has not been executed. Peremptory 60.
Page 26.
7.
I leave it to your lordship.
That's the problem. The Honorable Supreme Court has made an observation which is
I'll leave it to
binding
you.
on all of us. কি বললাম এসব বলো?
He, in any case, he fails to appear.
বলো।
Again, you will take him in custody. No problem. If he fails to appear.
And their presence could not be secured. Paragraph. We have considered the rival contentions of the parties. Stop. We are not happy with the explanation advanced on behalf of the state. Stop. If two accused persons are absconding, comma, it was always open to the learned trial court to split up the trial. Stop. After following due procedure. Stop. What is important is that the Honorable Supreme Court, by its order dated October 19, 2023, observed that the charge should be framed as expeditiously as possible and preferably within 4 months from the date of receipt of a copy of the order. Stop. Copy of that order of the Honorable Supreme Court was received by the learned trial court latest on January 4, 2024. Stop. 4 months have elapsed since then. Paragraph. Accordingly, comma, we are inclined to enlarge the petitioner or bail. Stop. This we also do since we are of the view that inordinate delay in progress of trial results in breach of a citizen's fundamental right to speedy justice, to right to receive speedy justice. Paragraph. Accordingly. Stop. Accordingly, in such a case, comma, Section 37 of the NDPS Act would not stand in the way. Accordingly, 25,000.
grateful.
গুলো কেমন আছে?
My lord, I am praying for only 2 days accommodation on behalf of Mr. Kaur.
শোনো, এই তন্ময়, on the prayer made on behalf of the petitioner, comma, let this matter stand adjourned for the day. কি আসেনি আজকে আবার? ঠিক আছে, এটা করে দাও, আর করছি না।
এগারোতে কি আছে?
শবনম হাসিন।
Yes,
Order number 11.
11 Millard, I am for the state.
I am for the petitioner, my lord. My lord, allegation under section 21C29, lordship. I am in custody for 2 months, 24 days, lordship. Nothing has been recovered from me, lordship. From the co-accused statement, my name.
she's filed.
Millard,
Charge sheet submitted.
Charge sheet has been filed. Millard, what happened? He was absconded for 2 years. He has the case of 2022. He has preferred anticipatory bail before this honorable court, which was turned down on 13th of March. Thereafter, he surrendered only because due to
13th of March this year.
this year, and for his abscondence, the trial is not progressing, Millard.
How, what was the seizure? What was seized?
But Caesar was not from his possession, but the co-accused
25 bottles.
625 bottles of fentanyl.
Not from, he has been
But-
implicated on the basis of
The co-accused
Statement.
statement, he
He played away from his place.
they have stated that Malad kindly
Page
see
20.
once
Show me
page,
the
page
CD.
20. Yes, Malad.
Give me the
on what basis have you implicated him?
Malad, this statement, Malad kindly see once. It's only for his abscondence. That is
Anikul
not
Sheikh,
progressing.
Anikul Sheikh, Anikul Islam.
আমার নাম সাদ্দাম, আপনার জিজ্ঞাসায় বলছি আমার নাম সাদ্দাম হোসেন। সাদ্দাম হোসেন। There are 3 Saddam Husseins. Now আমি কোন সেই
Malad may be the same person or may not be.
Same
But if the address is the same, it is the same person. Same person.
একই তো case.
Then
you have not placed before magistrate the 161 statement implicating self-incrimination.
Malad,
Is it acceptable? নিজের বলুন।
But I have said at the inception that nothing is there, only on the basis of 161 statements. But Malad kindly consider the conduct of the petitioner. For his abscondence, Malad, other two accused persons are
Nothing
suffering.
has been,
প্রচুর abscond করার পর anticipatory bail refused হওয়ার
Yes.
পর
Everything
lordship,
is ready. WP was issued.
nothing has been recovered from me, lordship. And lordship,
Why are you hiding?
how can I know, lordship, that a case has been initiated against me, lordship? I have no connection with this type of allegations, lordship.
Very well. Stay for some time more.
Lordship, kindly, lordship.
The petitioner says that he is in custody for about 2 months and
24 days.
24 days. Stop. There was no recovery from him. Stop. He has been implicated on the basis of statement made by a co-accused. Stop. He should be enlarged on bail. Stop. Paragraph, learned advocate for the state points out, the state produces the case diary for our perusal. Stop. We have read the witness statements recorded under section 161 CRPC. Stop. The statements clearly implicate the petitioner. Stop. Further, comma, we are told that the petitioner was absconding for about 2 years. Stop. In March this year, comma, he applied for anticipatory bail. Stop. That application was dismissed by a coordinate bench. This court.
This honorable court.
By a coordinate bench. Stop. Only thereafter, comma, the petitioner surrendered.
Fine.
Stop. Paragraph, in view of the aforesaid conduct of the petitioner,
Lordship,
comma,
lordship,
We
may I pray, lordship, at any condition, lordship,
we are not inclined to allow the petitioner's prayer, comma, at this stage. Stop. তাই তো?
Very habitual of it.
হ্যাঁ।
Stateful.
হুম।
Plan for the petitioner, my lord. My lord, this is a case under section 21C29 of the NDPS Act. The petitioner is in custody for more than 3 years, 8 months. My last occasion, my prayer was rejected by the Honorable Court on 12 May 2023 on the ground the co-accused prayer was turned down by the Honorable Court, and there's a direction to the court below to conclude the trial within a year.
Where's that order?
Yes, your lordship kindly see is the order of the co-accused. Prayer was turned down and there is a direction upon the court below, and that order was communicated to the court below. You know, it appears from the order number 8, that is 16th May 2023. Lordship will kindly see in the middle. On perusal of the case record, it appears that the case involves recovery of 256 grams of brown sugar, and by the order dated such and such in NDPS case number, the Honorable Court has been pleased to reject the prayer for bail of the accused Rajiv Akhtar during this court to expedite the trial. And your lordship kindly sees the ordering portion of this Honorable Court, second page. There's a direction to conclude the trial within a year. Then thereafter, your lordship turn the entire order sheet I have annexed, my lord. Only one occasion, one witness
What is the
turned up.
stage?
Yes. that's it.
Out of 10 witnesses, only 2 witnesses has been examined by this time. After communication of the order of the Honorable Court, 1 year has already expired, but only 2 witnesses has been examined.
What are you showing?
This is the day-to-day progress in the trial. It is a fact, my lord, that only 2 witnesses have been examined. Next
So
date,
another 2 years it will take at least? কি করবে বলো?
From the order sheet, it appears
but he was arrested on spot with another co-accused person with 256 grams of brown sugar. Direct recovery from him. His
Joint possession.
Yes. His
Joint
signature
possession.
is appearing in the Caesar list.
But considering the in an identical case, considering the decision of the Honorable Apex Court of Ravi Prakash versus State of Odisha, our this court also granted bail in respect of the after expiry of 1 year 9 months. Now we are in custody for 3 years 9 months, and out of 10 witnesses, only 2 witnesses have been examined, and moreover, the direction of the Honorable Court has been ignored by the trial court. No step has been taken to ensure the attendance of the witnesses.
Stringent conditions. Issue.
If he fails to appear on a single day, your bail will be cancelled.
Yes, sir.
Commercial quantity of heroin was seized from the joint possession of the petitioner and another accused person.
And another 2 persons.
Another joint petitioner and 2 other accused persons. And 2 other accused persons. Stop. The petitioner's prayer for bail was rejected earlier on several.
Another person.
Another person. Only 2 persons. 2 persons.
Why you
Only 2
confuse us
persons.
unnecessarily, sir?
Two
Sorry.
persons.
You তাহলে বুঝেছো? Another person. Petitioner's prayer for bail was refused earlier on several occasions, lastly on, when was the last rejection?
Last rejection on 12 May 2023.
May 12, 2023. Stop. Paragraph. Learned advocate for the petitioner says that by an order dated April 17, 2023, whereby the petitioner's bail application being CRM bracket NDPS 753 of 2023 was
And that is of the
disposed of.
of the co-accused.
This is co-accused.
Yes,
ও আচ্ছা কি বললাম whereby petitioners na whereby the bail application of the co-accused, namely Rajiv Akhtar, comma, being CRM such and such, was disposed of, was rejected by a coordinate bench, comma, the bench had also directed the trial court to conduct the trial as expeditiously as possible, preferably within 1 year from the next date fixed for recording evidence without granting unnecessary adjournments to either of the parties. Stop, unquote. Stop learned advocate says that in spite of such direction, comma, only 2 out of 12, 10 witnesses have been examined till date. Stop. It is anybody's guess, nobody's guess লিখেছিলে কালকে, anybody's guess as to when the trial shall conclude. Stop. The petitioner has already been in custody for about 3 years and 8 months. Stop. Paragraph, learned advocate for the state says that as much as possible, comma, the trial is being expedited. Stop. Due to certain reasons beyond the control of the learned trial court, comma, the trial is yet to conclude. Stop. There is clinching evidence against the petitioner. Stop. Section 37, keeping in mind the restriction in Section 37 of the NDPS Act, comma, the petitioner's prayer should not be allowed. Paragraph. We have considered the rival contentions of the parties. Stop. We are constrained to observe that there has been inordinate delay in the progress of the trial. Stop. A coordinate bench had directed the learned trial court to conclude the trial within 1 year. Stop. Such time has also elapsed. Stop. There is no possibility of the trial concluding at an early date. Stop. The concept of liberty enshrined in personal liberty enshrined in Article 21 of the Constitution of India must be given due importance. Stop. In such a case, comma, Section 37 of the NDPS Act would not stand in the way of granting bail. Paragraph accordingly. 25,000, one of whom local, and every day attending, etc., etc. Usual conditions.
deeply obliged.
The trial court will be entitled to cancel bail without reference to us if there is any breach. ওগুলো আছে তো সব দেওয়া?
Deeply obliged.
হ্যাঁ কি বলছো?
Cannot leave his local address.
Hearing you. Yes.
My lord, I am petitioner. My lord, I am in custody for last 3 years, 3 months. My lord, my bail prayer was lastly rejected by this honorable court on 5th April 2023. That is at page number 14. My lord, whereby it was directed that it is required to be concluded within 1 year. That has been elapsed. 3 years, 3 months, my lord, and out of 15, only 4 witnesses have been examined. 11 still are to be examined. My lord, your lordship on yesterday was asking for this judgment of
Chaudhuri.
yes, my lord. My lord, this is that judgment, and this is based on another order passed by Honorable Justice Dipankar Datta's division bench, Ravi Prakash. Para 4 in Ravi Prakash, and in that order, my lord, the Ankur
This is
Chaudhary's
your fourth application or third?
fourth
This is his fourth
fourth
application.
application.
Lordship will kindly take from paragraph from page 10 from the first rejection sort.
This is intermediate quantity.
From me, my lord, 13.05 grams of heroin has been examined, has been recovered. My lord, recovery of total 7 kilograms of heroin from 3 persons. My lord, I am not amongst them. My name transfers from
Mr.
their statement.
The ground on which you are praying for bail has nothing to do with the merits.
Exactly,
really.
exactly, my lord. Only long incarceration.
And my lord, what
3
my
years,
learned
3
friend
months.
has submitted because of the trial not being done. Lordship will kindly take this. I have prepared, the investigating officer is present. He has prepared a note. But on the last 6 to 7 occasions, the adjournments were taken on behalf of the defense.
Why adjournment was taken?
My lord,
The
I
last
don't have,
page.
my lord, I don't have that
That is
instruction.
very
As-
material, sir.
Definitely, definitely. And my lord, I don't have the order sheet. My lord, kindly adjourn this for 7 days because this is a police
But
report.
I have the
My lord,
certified copies of the order sheets.
Find
My lord,
out, find out.
My lord, let him
I
supply.
have the certified copies of the order.
Give him, give him.
Yes, ma'am. Well, then will I adjourn this for only
Yes, yes,
2
yes.
days?
This is the petitioner's fourth application, praying for bail. Stop. By the last, by the order dated April 5, 2023, passed in CRM bracket NDPS bracket 641 of 2023, while rejecting the petitioner's prayer for bail, a coordinate bench has had requested the learned trial court to expedite the trial and the court conclude the same at an early date, preferably within 1 year from the next date fixed for recording evidence without granting unnecessary adjournment to either of the parties.
Keeping in mind
Either of the parties.
ailments. I have
in
an
view
eye
of
issue.
in view of the submission that the petitioner is suffering from ailments. Stop, unquote. Paragraph. Learned advocate for the petitioner says that in spite of such direction, only
Only another 1 witness have been examined. Total 4 have been examined till date.
Out of
15.
only 4 out of 15 witnesses have been examined till date. Stop. The petitioner is in custody for
3 years, 3 months.
3 years and 3 months. Stop. He should be granted bail. Paragraph. Learned advocate for the state has prepared a bunch of certified copies of has prepared a list of dates showing that several adjournments were obtained on behalf of the present petitioner at the trial during the last 1 year. Stop. Learned advocate for the petitioner says that he needs to take instructions on this aspect. Stop. On his request, let this matter stand adjourned for a week and be listed again.
Only this day, my lord.
Only
Tomorrow-
this day?
tomorrow,
Oh,
yes.
stand
Because
adjourned for the day.
he is having the certified copy, he is saying.
Stand
But I
adjourned for the
will,
day.
I am producing the
No,
list of dates.
who claims to be juvenile in this proceeding? Who claims to be a juvenile in this proceeding?
No, my lord.
Who's the-
As far as I know, in this,
One Irfan Khan.
He is not the infant.
no, I am not.
This present petitioner is the mastermind. He used to order through Shomobai Bank in a various financial channels.
You show us those orders seeking adjournment tomorrow. Let him come.
My
back.
lord,
I have given what my investigating officer has just handed over to me. This is your lordship's order rejecting bail on 22nd of May of another co-accused, Lungnappa.
22nd of May, 2024.
Yes, ma'am. Lungnippa.
Right.
On the same road.
Very well. Come back tomorrow.
Yes, ma'am.
Give him a copy of this
Fine,
also.
fine.
After taking instructions, he may not want to press this application tomorrow. Let us see.
But I'm handing over a copy of the list of dates to my
না আমাকে সার্টিফাইড কপি দাও
এখানে সব লেখা রয়েছে
না সার্টিফাইড কপি দেখবো
তাহলে
certificate
তুলে
copy
নাও
তোমার কাছে তো আছে তো কত
Yes, next.
দাও
Order number 14.
কপিটা দিয়ে দাও
My lord, item number 14, I am for the petitioner, my lord. This is a case under section 21C29 of NDPS Act, my lord. Petitioner is 64 years old, aged person, my lord, is in custody, my lord, 94 days. No fencidal recovered from the possession of the petitioner, my lord. It is 100 bottles fencidal recovered from two persons, my lord. One Srikanto Sadhukan, my lord, another is Govinda Mandal, my lord. Even petitioner is not named in the FIR, my lord.
Yes, sir.
But co-accused statement, his name is transferred, but investigation is going on. Charge sheet has been-
Charge sheet not.
I'm 94 days custody, my lord. I'm suffering from illness, my lord.
What has the co-accused said?
But co-accused said that they were
My lord, these are the medical documents, my lord.
page double.
এটাও fact যে
11 and 12. But they have said that they are
Ah.
showing this to this petitioner the contrabands as a sample because he deals with the brown sugar and
But if I,
let the charge sheet be filed.
my lord, then,
Investigation
my
is
lord,
on.
keep my application pending, my lord.
No.
My lord, I'm not pressing this application, my lord. Then, my lord.
Learned advocate for the petitioner says that he has instructions not to press this application. Paragraph is dismissed, CRM such and such.
Sir, co-accused statement, my lord, is inadmissible, my lord. Section 25 of Evidence Act, my lord. Apart from that, there is nothing, my lord, till date.
We are not recording evidence. It's an investigation stage.
My lord, maybe, my lord. Even if I was not arrested, my lord, then I'm entitled to get anticipation.
Yes, next.
Yes,
But you have not pressed these.
yes, my lord. I have not pressed because your lordships are not inclined at this stage, my lord. Because your lordship-
You read the mind of the judges.
Yes, my lord. Yes,
Thereafter you are not pressing.
15.
May please. My lord, so far petition number,
the de facto complaint.
my lord, petition number 1 and 2 are concerned, my lord. I am renewing the prayer for bail. And also, my lord, the special petition was rejected by the apex court in respect of petition number 1 and 2. But petition, that is, my lord, the about a year back. But petition number 3 is the fresher before your lordship.
State shall submit report. State shall submit report.
On the last occasion, when the matter was heard, my lord, by the earlier division bench.
Mr. Boithro, there's an order. That's what we are saying.
Yes,
The
yes,
state shall.
yes. That's I am, my lord.
What is there?
But Rashi, what is the conduct of this IO is this? Each and every day, when the matter is posted in the list, at 10:15, he is handing over the case diary to us. After the matter is over, he is taking back the case diary. So not a single day I get the chance to read the case diary. So Rashi, kindly make it not today. I have the report, but I don't.
I am in custody for more than 4 years.
Come back tomorrow. One day more will matter.
Court has also rejected his prayer for bail.
That I have said. On the last occasion, my lord, back tomorrow. Only election stood in my way. Election stood in my way and matter was fixed. Let the election be over.
On the prayer made on behalf of the state, comma, let this matter stand adjourned for the day.
Lord Governor.
Sixteen.
Hmm.
Hello, it's a case of section 6 of Pocso. Petitioner is 20, girl is 16 years of age.
Resign করতে হবে।
17,
May please, Lordship.
Lordship, beg to appear on behalf of the state, my lord.
May please, Lordship. My lord, Lordship, kindly-
I am appearing on behalf of the state, my lord. The may I just prefer day accommodation, my lord. The original case date is not available.
CD not available.
This case was, my lord, adjourned for the want of custody. Lordship, kindly see the last order, my lord.
Lordship, today is the date
Of
fixed
May
for
2024.
There is no order. It just says matter will appear after summer
Yes,
vacation.
my lord. Adjourned, that my learned friend will.
my lord, and particular last date, my lord, it was the charge was not framed, my lord. Subsequently, charge has been framed, my lord. Today is the date fixed for, my lord, evidence of CW1, CSW1, lordship.
Come back with your CD tomorrow.
Lordship, great lordship.
Not day after করবে কেন? শিয়ালদার মামলা? আমরা তো কোর্টে আছি।
/ 18,
My lord, I'm happy. Now for the state. Lord, offences under section 302, 201, 120B of the Indian Penal Code.
No,
Petitioner is in custody for more than 3 years.
yes.
My lord, 302, 201, 120B. Petitioner is in custody for more than 3 years, 7 months. My lord, in March 2023, petitioner's prayer for bail has been rejected by this honorable court with a direction to conclude the trial, preferably within 1 year. My lord, page 8, I have annexed the order. Last paragraph is the relevant part. My lord, that order was duly communicated to the trial court. My lord, in spite of this, my lord, out of 31 witnesses, only 3 witnesses have been examined. My lord, page 8, I have annexed the order. Last paragraph, my lord, there was a direction. Space over it. Witness এক বছরের মধ্যে
পারবে না।
3 out of 31. Now, case is based on circumstantial
It's
evidence.
the case of 302 first.
That is all very well. An order is there.
My lord, the order was there. The presiding officer was on leave on number of occasions. My lord,
That's his fault.
true, but my lord, the circumstantial
Where do you
evidence,
strike the balance, sir?
the change of circumstance has been fulfilled by the prosecution.
But I'm not.
There was a recovery. There was a last scene together. This boy has been strangulated. The body was recovered after 3 days. Every material is against him.
That has been considered by the last order.
My lord, moreover, the
After considering that, after rejecting the prayer for bail, the coordinate bench said that 1 year.
my lord, I bow down to your lordship's view. My lord, only one thing. The coordinate bench has granted bail in cases of 302, which is where the accused are already languishing in custody for more than 5 years,
To
not
me,
below
what
5 years.
my
Let
learned
my
friend is
learned friend
saying.
show one single order in a case of
Why
302.
there is
The
a
coordinate
direction.
might be.
There is a direction. Why is
Understood.
it?
There may be a direction, but
Lord.
then we have to also look at the reality.
Yes, my lord,
Cannot
looking at the
blindfold it.
reality, looking at the reality, my lord, kindly
Series of
consider
164 statements.
out of 31, only 3. Only 3.
Last seen together.
Yes, 164 statement, recovery of the victim's mobile, the laptop,
mobile
the iPhone, and the
But
from
this-
whose the recovery has been made, he has made a 164 as well.
My lord, kindly consider, my lord, I am not on merit. My lord, I am on infraction of Article 21. My lord, had it been a case, only 10 witness, 15 witness, only 3 witness, my lord, I am in custody for near about 4 years. Kindly consider, my lord.
Very well.
any incriminating evidence against him?
Everything against him.
Last seen together.
Everything.
164 statement.
That is what I'm
last seen
saying.
Together. My lord, 302, my lord, in a case of 302, there's supposed to be evidence against me, my lord.
There are evidences,
There's
my lord.
supposed to be evidence against me. What my learned friend is saying, why I will, my lord, submit any bail order in respect of other matters. There was a specific direction. Had it been a case, 10 witnesses, 12 witnesses.
Of course, substantial time was lost due to
Yes,
pandemic.
I'm on that, my lord, kindly consider.
Pandemic. What do you mean I'm on that?
This is after pandemic.
That's
This
a case of
is-
2020.
No, 23 this order.
Case
No,
of
Case
2020.
of 2020, my lord, 23.
No,
this
sir,
order.
not at this stage. Issue.
You are not released at the time of COVID from
My lord, then, my lord,
Not press, not at this stage, we'll say. So if you don't want to press it, don't press it.
then don't take me amiss. Otherwise, any direction by this honorable court, when there is a direction, I am just consider it. Otherwise, in every case,
Expenditure disclosure.
in every case,
Preferably within 1 year,
preferably
it has
within
not
1
been
year.
possible. So we can, what
Only
we
3 witness out of 31,
If the
Only 3 witness, kindly consider,
If the
I am on infraction of Article 21. In 302
No.
case, to be evident.
So we'll extend the time. We'll extend the time and we'll say if within that extended time period it is not concluded, you'll be entitled to renew your prayer.
That's it.
This is the best we can do.
Deeply.
Yeshu. The petitioner renews his prayer for bail. Stop. How many times rejected, sir?
Once.
Once.
Stop. His prayer was earlier rejected by an order dated March 14, 2023, whereby his bail application being CRM bracketed DB bracket close 925 of 2023 was rejected. Stop. However, a coordinate bench directed the trial court to conclude the trial as expeditiously as possible, preferably within 1 year from the next date fixed for recording evidence without granting unnecessary adjournment to either of the parties. Stop, unquote. Paragraph. Learned advocate for the petitioner says that in spite of the aforesaid direction, only 3 out of 31 witnesses have been examined till date. Stop. The petitioner is now in custody for
3 years, 7 months, 19 days.
3 years, 7 months, and 19 days. Stop. He is renewing his prayer for bail, not only because the aforesaid direction of the coordinated bench has not been followed, but also because his right to personal liberty under Article 21 of the Constitution stands infringed by the inordinate delay in the progress of the trial. Paragraph. Learned advocate for the state opposes the prayer for bail. Stop. He produces the case diary and draws our attention to statements recorded under Section 164 CRPC, which prima facie incriminate the petitioner. Stop. The charge is of murder. Stop. The petitioner was, as per the statements of the witnesses, the petitioner was last seen with the deceased victim. Stop. Mobile phone of the deceased victim was recovered.
The motorbike.
Motorbike.
Yeah, the
Oh, not
motorbike,
mobile.
the laptop, the motorbike, the laptop, and the iPhone.
Tab has been
And
recovered.
And the iPhone.
Stop. The victim's motorbike, laptop, and
It's a
Not
tab.
from me, that is from a different person.
No, man.
iPhone.
Sure, not from
Yeah,
me.
yeah, yeah. Very well. Manoj will kindly have a look into the. When my line friend is challenging this part,
Why he's saying challenging? I'm
Lord.
submitting.
my lord, page 34 first. Yes.
See from whose house? আমার ঘর থেকে?
দেখাচ্ছি ভাই। Yes, he has made a 164. Should be my
Not from my house.
from the wife from whom it was recovered.
ওটা ছেড়ে দাও। ওটা
We are
ছেড়ে দাও।
recording submission only.
হ্যাঁ?
Yes. No, he's saying
ওই
challenging what I
সেন্টেন্সটা
can do.
কেটে দাও।
Not from my house that has been recovered. He's
Stop.
saying challenging.
He says that every effort is being made to expedite the trial. Stop. Paragraph. Having seen the material in the case diary and the prima facie evidence incriminating the petitioner, and considering the gravity of the alleged offense, we are not inclined to allow the petitioner's prayer for bail, at this stage. Stop. Paragraph. However, we direct the trial court. However, we express our disappointment. Disappointment in the learned trial court not having complied with the earlier direction of the coordinate bench, comma, for whatever reason, stop. We direct the trial court, the learned trial court, to conclude the trial positively within the next 8 months. 8 months,
Well, can it be 1 year?
very well. Within the next 1 year, comma, failing which, comma, the petitioner will be entitled to renew his prayer for bail.
Deeply. No, no, আমরা পড়া লিস্টটা জেনারেল বুঝে পাবেন
For the state.
When? No. Yeah.
Holding a meeting at 12:30.
You see, I was in Kurseong during the vacation. I was staying at a place which was run by a lady who said Arindas was her push shushu. So that's how the context of Mr. Das came up just 3 weeks ago in Kurseong. That's very sad to hear that.
So we'll be holding a meeting today at 12:30.
Very well, do that. Yes.
Please, Your Lordship.
He was a perfect gentleman. He was a perfect gentleman. Yes.
19.
Appearing for the petitioner, Your Lordship.
I
May I
am for the
please?
victim girl.
Your Lordship, this is the case of Pocso. The affidavit of service to the victim girl be kept on record.
আগে ওইটা খুলে দিন আমাদের দেখি।
Your Lordship, because of the
Appeared,
insufficiency of the address, the service was not complete.
No, he has appeared now.
It is appeared. But for the record, let it be there. Your Lordship, the sections are section 363, 366 of the Indian Penal Code and section 4, subsection 2 of the Pocso Act. In summary, my submission is that
What is the age of the minor?
that is disputed, Lordship. It seems that it is 14 years, but the mother said that she is not 14 years. There problem with that. First of all, that is a dispute of the age. Secondly, my point of submission is kindly comes at page number 9. That is the deposition of the victim girl.
And what is the petitioner's age?
Petitioner, Your Lordship, is 26 years old. As of now, 26 years old.
And time of occurrence, year of
The time of occurrence, he was 24 plus.
The occurrence of 2022.
Occurrence of 2020.
Yes, which portion? Page?
Page number 9, paragraph number 4. If I may be permitted to read out loud. I love accused person and fled away with the accused person to Shalboni, and from there police personnel of Inpur police station recovered me. Nowhere in the examination in chief she said anything about the point of sexual relation. She admits to the point of having love affair. She admits to the point of voluntarily running away. Nothing about sexual relation at all. Hence, Your Lordship, she was declared hostile. When the prosecution cross-examined the victim girl because of her being hostile, suggestion was put forth to her regarding the point of sexual harassment. If Your Lordship comes at page number 10.
What is the medical examination report?
Medical examination, Your Lordship, there is no external injury to suggest that there was forceful sexual assault. I apologize that I have not annexed it, but
nothing.
No, nothing. No,
she was examined.
Examined. Page 84, but no forceful.
Nothing.
In the evidence, there is no mention.
Like rupturing of the.
And my lord, 160.
Medical.
Page 84, man.
84.
Your Lordship, may I be permitted to point out one fallacy of the 164 statement as well. If Your Lordship comes at page number 11, paragraph number 2 of the cross-examination by accused person, there is a fallacy in the 164 statement as well. Because the victim states, it is correct that I stated about the incident before the London magistrate as per tutoring of the police.
Examination?
Pardon, Your Lordship?
Question number?
This is, Your Lordship, page number 11, paragraph number 2, cross-examination by the accused person.
Victim girl has turned hostile.
Your Lordship.
In 164, the allegation is there,
Issue.
but in the deposition, there is nothing.
Report is not, also not supporting you.
The charge is under sections 363/366 of the IPC, read with section 4(2) of the Pocso Act. Stop. Apparently, the petitioner was about 22 years old at the time of alleged occurrence, and the victim girl was about
Was about 14 years, around 14 years.
14 years old. Stop.
What is your statement?
Lordship, we don't stand in the way of granting of bail.
Stop. Paragraph. The petitioner says that there was an affair between him and the victim girl. Stop. The petitioner did not do anything forcibly. Stop. No sexual relationship was entered into by and between the petitioner and the victim girl. Stop. The allegation made under the Pocso Act is totally without substance. Stop. He is in custody for
1 year, 3 months, Your Lordship.
1 year, 3 days.
1 year, 3 months.
3 months. Stop. Stage of trial.
5 out of 18 witnesses has been examined till date.
Stop.
As one
Only 5 out of 18 witnesses have been examined. Stop. Nobody can say when the trial will conclude. Stop. He should be enlarged on bail on such conditions as this court may deem fit and proper. Paragraph. Learned advocate for the state produces the case diary. Stop. We have seen the statements of witnesses, including the victim girl. Stop. It is significant that while recording her evidence, the prosecution, while being cross-examined, while being examined in chief by the prosecution, the victim girl was declared as a hostile witness. Stop. This naturally causes a big dent into the case of the prosecution. Stop. The medical report also does not prima facie support the prosecution case. Paragraph. On an overall assessment of the material on record and the possible extent of learned advocate for the de facto complainant, for the victim girl, also says that he does not stand in the way of grant of bail to the petitioner. Paragraph. In view of the aforesaid and on an overall assessment of the material on record and the lengthy detention of the petitioner, we are inclined to allow this application. Paragraph accordingly.
Grateful, Your Lordship.
Yes, sir.
Yes, ma'am. For the state.
I am for the petitioner. 489B, 489C of the Indian Penal Code. The only ground on which, I am praying for bail before your lordship is the delay. 1 year and 2 months I am in custody. On the last occasion when this application was moved on 6th of May, a report was called for by the coordinate division bench as to the progress of trial. Because at that stage, the charges were not even framed. Now my instruction is after that order being passed by the coordinate division bench, the charges have been framed. But the witness action is yet to commence. The next date is on 16th of July for the examination of.
How many witnesses?
There are 19 witnesses in total, and not a single witness has been examined.
On last occasion,
After this honorable court, nudged. Thereafter, the charges could be framed.
2,98,800.
Yes, that is there, but there's
2,85,000. Well, huge, currency, fake currency. This is the the seizure list,
Subject to correction, there is no antecedent.
We will fix a time period, come back if necessary after that.
Will give me that default,
Yes. That default anyway you have, you know that.
But my lord, those 5 words from your lordship
Strengthens your hand.
hold into my case.
Esho? Esho Baba. Zakir Hussain? Na, Nashiul Haq.
Last order is the last page, my lord. Last page of my report, my lord.
Who accused was granted bail.
They on the ground that there was no recovery from his
Yes,
own.
no recovery.
My lord,
The principal
that's
accused,
why I
my lord.
didn't argue that point. My lord.
The charge against the petitioner is under sections 489
B and
B and
489
C.
C.
And 120 B, my lord.
capital B and 489 capital C IPC, IE, dealing in fake currency, stop. Dealing in fake currency, stop. Apparently, কত টাকা বললে?
2,85,000.
2,85,000, my lord.
Stop.
5,500.
Apparently, fake Indian currency
Value
of the value of approximately rupees 2,89,000.
85.
85. 2,85, 500.
My lord,
2,85.
2,98,000, my lord, in total, my lord. But in the first seizure list, my lord,
Yeah,
2,00,000.
approximately ওইটা দেখো, approximately ওইটা
Initially, I told you,
Uh,
but you
was recovered
suggested.
from the possession of the petitioner. Stop. Paragraph, the petitioner says that he is in custody for about 1 year and 2 months. Stop. When this application was moved, the charges had not been framed. Stop. By an order dated May 6, 2024, a coordinate bench had called for a report from the state regarding the status of the proceedings and the reason for delay. Stop. Paragraph, such a report is filed in court today. Stop. It appears that after the last order of the coordinate bench, charges have been framed on June 5, 2024. Stop. Paragraph. We understand that there are how many witnesses?
My lord, 19.
19 witnesses. Stop. Witness action is yet to begin. Stop. Given the gravity of the charges against the petitioner and the prima facie incriminating evidence against him as found in the case diary, we are not inclined to enlarge the petitioner on bail, at this stage. Paragraph, however, since the petitioner has been in incarceration for a long period of time, we direct the learned trial court to expedite the trial as much as possible and bring the same to its logical conclusion at the earliest and preferably within a period of 1 year from the date of communication of this order.
Most witnesses are police officers and formal witnesses. Shouldn't take, ordinarily, that doesn't take much time.
Then how much? He is wanting more.
I was requesting 6 months.
1 year, 1 year. Stop. From the date of communication of this order, stop, order, now stop. In the event the trial is not concluded within the aforesaid time period, the petitioner may renew his prayer for bail.
Status report will be kept and in record, my lord.
Status report has been filed, বললাম না, today. Let the same be kept with the records. হ্যাঁ, আমি জানি এটা।
একই দেখাবো এটা রিজেক্ট 21
I appeal for the petition, lordship.
Lordship, charges under section 302. I am the sole accused, Lordship. Lordship, the state of event goes as such. The de facto complainant complained that in the month of August, he heard some shouts that his son was being stabbed by this accused person. And thereafter, he was in a critical condition. He was taken to a local Srirampur government hospital. But interestingly, neither a complaint nor a FIR, nothing was registered. Thereafter, he was treated, he was operated, and he was coming back and forth. in the month of November, he succumbed to these injuries. That is the allegation, Lordship. And on the very next day, this FIR was registered. I am in custody for 140 days. Interestingly, Lordship would find that in all the FIR, in fact, the 161 statement, the alleged weapon is a steel knife with a plastic butt. And the recovery was being done of a rusted iron knife with a wooden butt, Lordship. And there is no statement from the in the 160. I do not know the 164
There
part
are three
about
164
the
statements of the
their
eyewitnesses, specifically implicating this petitioner. Moreover, there is a seizure of the.
There is no eyewitness.
There are three eyewitnesses.
Three eyewitnesses?
Three eyewitnesses. There 164 has
Of
been
the
recorded.
incident, eyewitnesses
Of
of
the
the incident?
incident, Incident
Lordship
happened in
sees
front
the,
of them.
Lordship sees the FIR once. Chitkar Shune, she went to the spot, de facto complaint.
Whether we shall evaluate the evidence right now.
No, Lordship. I'm just asking, he's saying an eyewitness, that's why. And the seizure also, Lordship, you would find, Lordship.
Only commitment has been done, madam.
Commitment.
The charge sheet have been framed.
Only you had 141 days only.
141 days.
দেখো ইনক্রিমেন্টিং থাকলে রিজেক্ট করেছি at this stage
There is a lot of discrepancy and there was no complaint even lodged when there was an alleged stab, Lordship. I do not know. The charge sheet have been submitted, nothing there.
এসো 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 the charge is of murder. Stop. The petitioner says that he has been falsely implicated. Stop. He has no connection with the alleged crime. Stop. The paragraph. Stop. The prosecution case is that now, according to the petitioner, comma, the prosecution case is that in August 2023,
21st August.
21st August,
2023.
that on August 21, 2023, hearing the victim shouting out for help, the de facto complainant, who was his father, mother, rushed to the spot and found that he was lying injured. Stop. The victim was taken to the hospital. Stop. No complaint was lodged immediately. Stop. Thereafter, ultimately, the victim succumbed to the injury in November 2020. On November 2, 2023, stop. On the next day, a formal complaint was lodged. Stop. Paragraph, the petitioner says that he is in custody for about 118 days. Stop.
143 days.
143 days. Stop. Investigation has been completed and charge sheet has been filed. Stop. His further detention is not necessary. Paragraph. Learned advocate for the state produces the case diary and refers to the statements of witnesses recorded under section 164 CRPC. They are eyewitnesses. Stop. Paragraph. We have postmortem.
There is a postmortem.
We have also perused the postmortem report.
Page 69.
Paragraph.
Cause of the death
On an
is
overall
equal of the injury.
appreciation of the facts and circumstances of the case and on an assessment, prima facie assessment of the material on record, we are of the view that there are sufficient incriminating material against the petitioner, and therefore we are not inclined to allow the petitioner's prayer for bail, at this stage.
Him and the accuser cousin.
Lordship, distant cousin.
Distant.
Dismissed.
Easier.
Oh, I am come here for seeking for adjournment.
22 and
22, 23, 43, and there is another matter not in the list. This arises out of the same case. Lordship kindly directs that it will be taken up.
When?
Right.
এই লিখে নিন যেটা বলছেন সাহেব,
43 আর ওই নাম্বারটা আপনাকে
আর যেটা নতুন দিচ্ছেন সেটাও সেদিন লিস্টে দিয়ে দেবেন।
43 আর একটা দিয়েছেন ওই যে
No, but Mr. Roy, who are appealing?
For the petitioner in 22 and 23. Well, they have all been informed. In fact, I have forced him to succumb to my pressure
Wait.
for adjournment.
Duress.
And duress he is considered.
Very well. Call the next matter.
On 24.
Yes, 24. Nay. Passover.
$25.
My lord, I am for
this day.
Yes.
This is a case of 302, my lord. And I'm in custody about 3 years, 6 months, and 20 days, my lord. Out of 25 witness, only 8 witness has been examined. My lord.
What is the quality of evidence?
My lord, last seen witness, my lord. Nobody is eyewitness, my lord, but last seen witness is there, my lord. Her statement is.
Any recovery pursuant to his statement?
My lord, from the leading statement, my lord, one bamboo stick was recovered from his residence.
Forensically examined.
My lord,
that is the offending weapon.
my lord, there was no blood stain.
No blood stain. Then which is the offending weapon? What was the nature of injury?
My lord, blunt injury, my lord, that is PM report 100 and 103.
Blunt injury, there should be some blood if that was the fatal blow. Very likely there will be some blood.
100?
103 is the PM report, my lord.
Three years, 6 months.
Yes, madam. 3 years, 6 months, 20 days.
Out of 25, my lord, 8 has been examined. And my lord, next schedule is
that
the month of June.
Is that a very happy pace? It's not.
That's not. My lord, next schedule is in the month of June. There are 4 dates, my lord, consecutive dates. My lord, Caesar list is, my lord, page 18 and leading statement page 17. One eight, my lord.
Sufficient incriminating materials.
Not at this stage.
Trial-
We'll indicate a time period.
Fine.
You may come renew your prayer after that. Esho.
My lord, on next schedule is, my lord, on June. There are 4 consecutive dates, and my lord, 8 witnesses are called, my lord, for deposition in the month of June.
Do whatever you want to. We are indicating a period of 1 year. The charge is of murder. Stop. No doubt it is a grave charge. Stop. The petitioner says that he has been falsely implicated. Stop. He is in custody for more than 3.5 years. Stop. Only 8 out of 25 witnesses have been examined. Stop. There is no possibility of an early conclusion of the trial. Stop. He should be enlarged on bail on such conditions as this court may deem fit and proper. Paragraph, learned advocate for the state produces the case diary and draws our attention to the material therein. Stop. He shows us statements of witnesses recorded under section 164.
161.
161 CRPC. Stop. According to such statements, the petitioner was last seen with the deceased victim. Stop. Further, the offending weapon was recovered pursuant to leading statement made by the petitioner. Stop. He says that next date. What did he say?
June, my lord. Schedule is on June, 20th June, 21st June, 24th June, and 25th June.
4 hearings have been fixed. Starting from in the last
schedule of
last week.
examination of
he says that he said
schedule of examination of witnesses.
A schedule of examination of witnesses has been prepared by the learned trial court, and witnesses are scheduled to be examined on
8 witnesses.
and 8 witnesses are scheduled to be examined on June 21,
20, 21, 24, and 25th.
June 20, June 21, June 24, and June 25, 2024. Stop. Learned advocate says that in view of the gravity of the alleged offense and the availability of prima facie incriminating evidence against the petitioner, the prayer for bail should not be granted. Paragraph, having considered the rival contentions of the parties and the progress of the trial, as also in view of there being prima facie incriminating material against the petitioner and the charge being of very grave nature, we are not inclined to allow the petitioner's prayer for bail, at this stage. Paragraph, however, keeping in mind that the petitioner has been in incarceration for more than 3.5 years, it is desirable that the trial is concluded as early as possible and preferably within a period of 1 year from the date of communication of this order to the learned trial court. Stop. In the event of the trial not being concluded within the aforesaid time period, the petitioner may renew his prayer for bail.
My lord, allegation under 307, 363, 363, 365, 506. Victims are already recovered. I am standing on the same footing, madam. Kindly see page number 7. Father got anticipated from this honorable court. I am for the mother. Mother got anticipated bail.
What is the age of the victim girl?
76 children.
Oh, she's 76.
My lord, already married. My lord, on
19.
My lord, already married on 3rd February on a counter case. Married 3rd February, can only admitted in the FIR. Can you see the FIR?
Yeah, for the Petitioner accused, what is?
My lord, 4 accused, 2 got anticipatable from the honorable court, page number 8.
Principal accused.
Principal accused already in custody, I am father of the principal accused.
Mother was granted bail. And marriage was taken place.
My lord.
Where?
My lord, at the Kali Mandir, Simla.
The allegation against this petitioner that
They are no husband wife.
No, entire allegation against the principal accused who is in the custody.
What is the age of the victim?
19 years.
Law affairs.
When they raised documents.
But say when
2 months back, my lord, 2 months back.
No, Pocso is not involved.
164.
Pocso
At
nahi.
that time, she was
Major.
19.
The father.
But see, he is the father, but allegation is not of 376 against this petition. Allegation that he assaulted with Hatua to one Alok Kumar Ghosh. But see, this is the 164. Same person, my lord, they in the 161 at first stage, my lord, they have
Sir,
stated
sir,
that this person assaulted.
You have filed, investigation is complete, you have filed charge sheet,
My lord.
62 years old
My-
man.
I-
Issue.
And Delhi 164 has more strain.
Absolutely. Absolutely.
The charge is of murder and conspiracy. Stop. The sections invoked are 302, 120 capital B and 34 of IPC. Stop. Sections 25 and 27 of the Arms Act have also been pressed into service. Stop. Paragraph. The petitioner says that the entire incident took place at a marriage party. Stop. He has no major role. He had no major role to play in the incident. Stop. The incident. Stop. He is in custody for 118 days. Stop. Investigation is complete. Stop. Charge sheet has been filed. Huh? Stop. He is senior citizen. He is a senior citizen, aged about 62 years. Stop. There is no reason to further detain him in custody. Stop. He should be granted bail on such conditions as this court may decide. Paragraph. Learned advocate for the state produces the case diary and draws our attention to the post-mortem report. Stop. He also places before us statements of witnesses recorded under section 164 CRPC. Stop. None of those three witnesses name the present petitioner. Stop. Paragraph. On an overall consideration of the facts and circumstances of the case, the material on record, the prima facie incriminating evidence against the petitioner, and given the fact that investigation is complete, and also that the petitioner is a senior citizen, we are inclined to allow the present application, but on strict terms and conditions. Paragraph accordingly. Stringent as it has দেখা করবে
দেখা করবে না ইপিএসসি কমপ্লিট হয়ে গেলে দেখা করবে
but on certain terms and conditions.
ACM Lalbagh. Lalbagh.
28 28 I am not pressing with the application.
Dekhe now, learned advocate for the petitioner says that he has instructions not to press this application for bail. Stop. Paragraph. CRM such and such is dismissed.
29
Not to attend court today from 2. And below the cremation will be held, as I have been told, that his daughter stays in America. She is amazed of a project, and that is why she is not getting any holiday. She would be coming on Sunday, and the cremation would take place on Monday.
Next Monday.
Next month. And after the cremation is being held, we will seek for a full court reference at 11:30 on the next available day. So, Milord, I beseech upon your lordship, knowing fully well that your lordship is hungry by that time, to sit sometime more today, at least till 1:30. Because today we don't have any court after.
We'll sit till 1:30. We'll also come at 2:15 and sit, call the list.
We can't appear. For our benefit, we not sit.
We'll sit till 1:30. No problem.
29
In item number 29, I'm appearing on behalf of the petitioner.
Yes.
Yes, my lord, just give me 5 minutes.
Passover.
5 minutes. Before 2.
Before?
Before
1:30.
We'll sit till 1:30. Mr. Mukherjee requested. Yes.
1:30.
Another resolution হয়ে গেছে?
1:30. 1:30. Before your lordship rises states.
Remind us, we may not remember.
Yes.
30.
Yes.
I'm applying for the de facto complaint.
My lord, 30234. My lord, near about 8 months I'm in custody. My lord, on the date of incident, there was a quarrel took place between two brothers regarding their landed property. This is the ancestral property. One brother assaulted another brother with a bamboo stick. One day after, another brother, my lord, succumbed to his injuries. Now, my lord, even if, my lord, the allegation is taken in its entirety, my lord, that petitioner has committed the offense, my lord, without any premeditation. My lord,
Heat of the moment.
Yes, yes, my lord, at base, my lord, 304. Now, on the date of incident,
Culpable homicide from amounting to
Murder.
my lord, on the
submitted.
Charge sheet.
yes, charge is submitted, my lord, 8 months I am in custody.
Kindly consider the
You are the younger brother or elder brother?
My lord, I am the
not kindly say.
younger brother.
Yeah.
My lord, I am the younger.
Yeah. Let me ask you, elder brother. Let me ask you.
This is the case where this petitioner initially started assaulting his own father, and thereafter the younger brother came to help the father, and then he assaulted the
Complaint
younger
down
brother
now.
to death.
He says he's the elder, he's the younger brother.
He is the younger brother. So, the brother came and he assaulted.
Dispute between brothers regarding ancestral
And
property.
initially, father was assaulted. The statement of father is also here, madam. Kindly peruse that.
Oh, yes, brother. Brother, যে মারা গেছে brother.
হ্যাঁ আমি তো younger
Accused
brother.
is still absconding, my lord. The wife of this petitioner is still absconding against him, my lord.
No, wife
Against
bill
her.
পেয়েছে তো।
And my lord, my lord, proclamation has been already.
Sir, is he a habitual offender like this? Is there any antecedent?
My lord,
And to
What will you gain by keeping him further in custody? Tell us. What will you gain?
the problem is that if he is in, he got bail, my lord.
Yes.
Both are residing in the same house.
I will not enter.
All the witnesses can be jeopardized, my lord, with his.
I will not enter to
He will not enter.
my lord, today is the date for framing of
not
charge,
enter.
my lord.
I will not enter into the
Etc. We have that in all our orders. They cannot. Tampering evidence, if it is found, bail will be cancelled immediately.
Man.
And they will not enter the police station, that jurisdiction of the concerned police station.
concerned police station.
Today's
My lord, there are several eyewitnesses there of the incident.
today will be framed, my lord.
Several?
Today is the date fixed for.
Yes, maybe.
Of the
Is it 302 or 304?
302. My lord, according to the statement, my lord, it can be said it's a 302, my lord.
My lord is asking ultimately what would be the fate, 304 or 302.
My lord, kindly peruse the statements, my lord. Page 10, 11, 12. And the postmortem report is page 67. Kindly see how many injuries are there, my lord, in the postmortem. But it is not a single shot, my lord. It is continuous repeat. Kindly see the postmortem report, my lord.
You are missing the point. Anyway. Yeah, sure. The allegation is that there was a fight between two brothers. Stop. The petitioner, comma, being the younger brother, comma, beat his elder brother to death with a bamboo stick. Stop. Paragraph. The petitioner says that the charge of murder will not lie. Stop. There was no pre-planned act on the part of the premeditated act on the part of the petitioner. Stop. There was a quarrel between two brothers concerning joint property. Stop. In the heat of the moment, the petitioner dealt blows on his elder brother, which caused his death. Stop. He is in custody for
My lord, 7 months, 25 days.
7 months, 25 days. Stop. Investigation is complete. Stop. Charge sheet has been filed. Stop. Charge has not been framed.
My lord, today is the date fixed for charge, framing of charge.
Very well. Stop. No useful purpose will be served by continuing to keep him in custody. Paragraph. Learned advocate for the state as also learned advocate for the de facto. Who is the de facto?
My lord, I am. My lord, wife, my lord, the deceased wife.
De facto complainant being the wife of the deceased, victim, comma, strongly oppose the prayer for bail. Stop. The case diary is produced. Stop. Our stop. Our attention is drawn to statements recorded under section 160
161 of the eyewitness.
one CRPC, comma, of eyewitnesses. Stop. The learned advocates say that their apprehension is that if the petitioner is enlarged on bail, comma, he will tamper with evidence and intimidate the material witnesses, thereby jeopardizing the trial. Stop. Paragraph. We have considered the facts and circumstances of the case and the material on record. Stop. Prima facie, it appears that the petitioner did cause the death of his elder brother. Stop. However, from the circumstances of the case, comma, it cannot be ruled out that there was no premeditated act on the part of the petitioner and the alleged offense was committed by him on the heat of at the heat of the moment. HEAT, heat, huh? The heat of the moment. Stop. Paragraph. Since investigation is complete and charge sheet has been filed, comma, we do not see how any useful purpose will be served by further detaining the petitioner in custody.
Grateful to.
Paragraph accordingly করে দেবে আচ্ছা তারপরে তাতে add করে দেবে the petitioner shall not enter the territory of the
Now the police station.
jurisdiction of the
Now the police station.
বানানটা নিয়ে না জেনে নাও
ওদের যেটা হচ্ছে
Let him stay outside the district, my lord.
police station.
The area is very adjoining, my lord. The Beldanga police station and Nauda police station is nearby, my lord.
30 kilometers. Well, that is nearby 30 kilometers. Nearby that is 30 kilometers. Well, I leave it to your lordship, my lord.
Remain outside Murshidabad district till the conclusion of the trial.
Grateful to.
Or till the recording of evidence is over. Till the recording of evidence. Till the recording of evidence is over. আর ওইগুলো তো থাকবেই, ইন্টিমিডেট করবে না, ট্যাম্পার ওগুলো আছে।
Only one thing, my lord. Or one thing. Furnish his address where he is staying and
He shall also furnish to the learned trial court.
trial court or the jurisdiction. Police station.
Learned trial court, the address where he will be residing. তারপরে যেটা আছে ইন ব্রিচ অফ এটা আছে না যে তো মুর্শিদাবাদেই থাকছে না তো তবে শোনো ওই ব্রিজ করলে ট্রায়াল কোর্ট ক্যান সেটা তো প্যারাগ্রাফ রয়েছে একটা দেখে নিও ক্যান্সেল উইদাউট রেফারেন্স টু আস। হ্যাঁ
31. My lord, I am appealing for the petition. My lord, yesterday your lordship, my lord, please to hear this matter. Yes. My lord, may I just indicate? My lord, out of 5 charge sheeted accused persons, 395, 4 are on bail. 2 co-accused persons have been granted bail as, my lord, the test identification parade. 2 co-accused persons have been granted bail as test identification parade has been found to be doubtful because there was no prayer advanced by the IO in respect of those petitioner for conducting TI parade. So for petitioner, there was a prayer by the IO. Now, my lord, on the last occasion, my lord was pleased to direct my learned friend to take instruction whether or not any prayer has been made by the IO in respect of the present petitioner as well as
Other accused persons.
Yes. Now, my lord, the Mukesh Shrestha and Avinav Dokania, they have been granted bail on that ground as because there was no prayer. Now, so far, Mukesh Shrestha, my lord, kindly sees there is a prayer by the investigating officer for conducting TI pen. I am standing on the same foot. My lord, this is the certified copy of the order. My lord, I am sorry, my lord, I've got one copy of the order, my lord, kindly. That order, page 15, I have annexed. Mukesh Shrestha.
See page 260 of the case diary.
Only on that point it was adjourned.
Page 260.
So in spite of that, bail was granted
Yes.
to Mukesh.
Yes.
260
I am
of the
standing
case
on the
diary.
same footing, 2 years, 27
Page
days I am in custody.
260 of the case diary.
260.
Yeah.
Okay.
Yes. This is the prayer.
Henry Robert. In case of me, there is prayer. In case of Mukesh Shrestha, also prayer, and they have been identified. In spite of that, bail granted. Standing on the same foot.
Yes, Mr. Mukherjee, this is his case.
My lord, I tell you, Lord.
Prayer.
My lord comes to page 25.
Yes, yes.
Comes to page 25.
No, it is true. It is true that Isai Chinmay Chakraborty has
Now, my lord, 289 comes to 289, the order.
there's a prayer.
289, 280, yes.
Now
289, the order. This is dated 6th of May. My lord, kindly sees the date. 6th of May.
289. 289. Yes.
7th of May's order, my lord, will kindly see. Immediately on the next day.
Certificate copy. Seen the prayer of what is the
See, my lord.
what is the date?
At the bottom, 7-5. 17-5. 16th is the prayer. 17th is the order.
Just seen the prayer of IO for TIP. That's not really knowing. So whole TIP, that is as per his convenience. Just a minute.
Immediately on the following day. 16th is the prayer.
It is the prayer.
The prayer is there or not? That
My
is
lord, I've seen.
in both the cases, there is prayer.
I tell your lordship. Now comes to page 25.
16/5/2020, there was a prayer
For holding TI parade.
GM Asansol through GRO. That is correct. And
17th is the order passed.
17th, but name has not been mentioned. Okay, 17th. Okay.
Immediately on the next day.
That is in respect of the petitioner.
Yes.
Petitioner. And in respect of Mukesh Shrestha, my lord, I have given the order.
Comes to page 20.
So there is an order.
There is an order.
There is a prayer for TIP.
Prayer for
That
TIP,
has
Mukesh
been
Shrestha allowed.
Your previous contention that
Yes.
there was no prayer.
No, it is not my contention. My lord, kindly comes to the order, page 15.
Yesterday.
My lord, kindly comes to the order, page 15.
Whatever
As
it is.
because there was no order,
And so far,
prayer by advanced by the IO,
yes.
this honorable court, my lord, was of the opinion that there was no prayer of the IO that was done by the jail authority. Jail authority does not have any power to conduct TI parade, save and except the order of the investigating officer. That is why bail has been granted.
My lord comes to page 25. My lord comes to page 25.
My lord, kindly comes to page 15, my lord would understand. Kindly comes to page 15.
That no prayer has been made.
Yes, page 15. Yes. Prayer has been made. So I am standing on the same footing.
Prayer has been made. Now comes to page 25.
All are on bail. My lord, page 15. So far Mukesh Shrestha is concerned, page 15. I have annexed. Page 15.
That time.
How is Henry's case different from Mukesh? Tell us.
How? I tell you, Lordship. Lord, he has been granted bail on the score that the TI parade has been done not in conformity with the law.
Who? Mukesh? No.
No, my lord, kindly see.
Page 15. My lord, kindly comes to page 15.
15 of what? Your application?
Yeah, my application.
That order.
My lord, kindly comes to
This
page
is,
13.
oh, this is Mukesh Shrestha.
My lord, comes to
Page
page 13. Page 13.
Oh, so this was factually incorrect then, what was recorded?
Factually, my lord, at that point of time, this honorable court was not properly assisted.
My lord, now come to page 13.
In respect of Mukesh Shrestha, there is a prayer by IO for conducting TI parade. In case of
Yes,
me
13.
also,
My lord, page
my lord, there
13.
is a prayer.
We are unable to understand how the jail authorities who are in no way connected with the investigation.
That is principal accused.
The principal
Followed
accused has
by
been
that
granted
order,
bail.
this order.
Now followed the other accused, Mukesh claimed parity. But now my lord comes to page 25. How the court has not properly been
25
assisted.
of what?
The case diary.
25 of case diary. Yes,
My lord
25.
kindly sees person in whose presence the column. There the jailer has correctional home has put his signature. The witnesses. The third column. In whose presence?
Assistant controller.
See, that was the notion of the court that it has been done by the jail authorities.
No,
Now,
how it can be?
now my lord
There
sees,
has to be in
now
front of jailer.
my lord sees the other part. Sees the other part in the margin. There is a signature of the magistrate.
Yes, that should
There
be
is
there
a signature
supposed
of
to
the
be.
magistrate. At the margin, there is a signature of the magistrate.
I have
who held
given,
the
there
TI
is a
parade.
prayer.
And this magistrate has been cited as a witness in the charge sheet.
Has to be. He has conducted the TI parade.
Witnesses must be magistrate.
Yes.
Yes.
Jailer must not be there. During the test identification parade, jailer must not be there. This is the law. Witness means that magistrate, because magistrate has to come to the additional sessions judge and prove this report.
Signature is there of the magistrate.
No. Which you are showing that is a remarks column. There in that column, magistrate puts his signature.
Right.
That is different thing. But assistant controller, jailer should not be there
But
because that is a frightening effect upon the inmates of the.
But my lord sees the top.
That is the law.
My lord
Only
sees the
prayer,
top.
both the cases, prayer
Sees the
is
top. What is
Unnecessary.
written? Sees the top.
That recording of Justice Bakshi was incorrect.
No, Mr. Basu, you do not stand on the same footing. You do not, because the court granted bail on the basis that there was no prayer from IO. So that was court was not assisted properly. In your case, there is a prayer from IO.
Yes, no, Mukesh Shrestha, there is a prayer. Oh, my lord.
Right, but that was not placed before the
Yes,
court.
yes.
Had that been
So,
placed, that bill may not have been granted.
My lord, rightly, wrongly. My lord, state did not challenge this order, my lord.
No, why have
State did not challenge this
I have
order,
wrongfully
my lord.
commissioned the police
You cannot be said to be on the same footing.
Now they are
Negative.
negatively, my lord, rightly.
Erroneous, no. There can be any negative equality, no.
Negative equality.
Cannot be. Sorry.
You could have assisted the court.
Only, my lord, kindly consider one thing. In a case of dacoity, in respect of the present petitioner, only TI parent. In respect of others, no prayer for TI parent. The investigation was done.
Why Mukesh there was prayer for
Only
TI parade?
Mukesh.
Yes.
So for other principal accused, Dokania,
Your
kindly see, kindly consider the statement of Sanjeev Prajapati, driver of the truck, who has identified the all. He indicated the presence of all accused persons. He has indicated the presence of all accused persons. My lord, kindly see. Only I have committed the offense of dacoity. My lord, kindly consider.
But court has not been assisted
I have
properly.
committed. The state was there. It is not my fault. And I didn't move
But
this.
as we say, there cannot be negative equality, sir.
My lord,
Issue. Yes. Issue.
Right. We have tried.
How many times your prayer was rejected?
My
How
lord,
many?
twice. My
Twice.
lord, last in September 2023. Page 9 and 10, my lord.
9 and 10. Dekho. The petitioner renews his prayer for bail. Stop. His prayer was rejected earlier by orders dated May 15, 2023, passed in CRM bracketed DB bracket close 1918 of 2023 and September 29, 2023, passed in CRM bracketed DB bracket close 3771 of 2023. Stop. Paragraph. The petitioner says that he is one of the 5 accused persons, Stop. The other 4 persons have all been enlarged on bail. Stop.
2 by this honorable court, 2 by land trial.
2 of the accused persons have been granted bail by this court, and the other 2 persons were enlarged on bail by the learned trial court. Stop. The petitioner cites an order dated Mukesh's order is page.
My lord, this rejection, my lord.
Mukesh. No.
Page 15, my lord.
Yes. Order dated April 17, 2023, whereby the bail application of a co-accused being Mukesh Shrestha, bracketed out CRM DB number 1496 of 2023, bracket closed, was allowed by a coordinate bench on the ground. Now, allowed by a coordinate bench. Stop. Learned advocates for the petitioner says that the present petitioner, stands on the same footing as Mukesh Shrestha and hence should be enlarged on bail. Paragraph. Mr. Mukherjee, learned APP, representing the state, produces the case diary and draws our attention to the relevant material therein. Stop. Prima facie, there appear to be incriminating evidence against the petitioner. Stop. Paragraph. We do not think that the petitioner and Mukesh stand on the same footing. Stop. We find from records that a prayer was made by the investigating officer for holding TI parade in respect of Mukesh. Stop. However, the coordinate bench, which was considering the bail application of Mukesh, was not properly assisted, and hence it was erroneously was not properly assisted, and such prayer of the investigating officer was not brought to the notice of the honorable bench. Stop. In fact, such prayer was made by the investigating officer. Stop. If such fact was drawn to the notice of the bench, it is possible that the bench may not have granted bail to Mukesh. Paragraph. In the present case, prayer has been made by the investigating officer for holding TI parade in respect of the petitioner. Stop. Therefore, there cannot be any procedural irregularity in that regard. Paragraph. On an overall assessment of the facts and circumstances of the case and the material on record, we are not inclined to enlarge the petitioner on bail, comma, at this stage.
Let there be direction for expeditious disposal, my lord.
So what is the stage?
My lord, 2 years, no charges not been framed yet, my lord. 18 witnesses.
Charge framed already.
My lord, kindly see.
12 June is the date for framing of charge.
Paragraph, Mr. Mukherjee, comma, learned APP says that June 12, tomorrow, comma, 2024, comma, has been fixed as the date for framing of charges. Stop. Let that be done without any adjournment. Stop. Further, comma, since you're in custody for?
My lord, 2 years, 27 days.
The petitioner is in custody for more than 2 years, comma. We request the learned trial court to expedite the trial and bring the same to its logical conclusion as at the earliest. At the earliest.
Great.
I'm great.
Yeah. দেখো ডেটটা অব্দি বসুন
32, Lord, I am appealing for the petitioner, Lord.
ডেটটা অব্দি Yes.
The dispute between two brothers with regard to the paternal property. The younger brother killed the elder brother.
Lovely. That's right.
Lord, the petitioner is in custody for 389 days, Lord.
Younger brother killed the elder brother just like that.
No, Lord. The quarrel took place at night with regard to the paternal property. At the heat momentum, the younger brother dealt a blow with a knife on the
Knife?
on the elder brother, and the elder brother died.
Fingerprints matched.
The petitioner is in custody for 389 days, Milord. Milord, charge has been framed. The material witnesses has been examined, Milord.
Lastly, turned down
Evidence against you.
my lord.
Milord, increment.
January it was rejected.
5th January it was turned down. Evidence is going on. Out of 23 witnesses,
only
7 have been examined.
7 have been
Seven have been examined.
That's very, very good progress.
Cut throat injuries.
My lord, it was cut. The air tube was cut. The dagger was recovered from his closet. The fingerprints matched. That report is there.
No, sir. Issue. The petitioner renews his prayer for bail. Prayer for bail. Stop. His prayer was rejected earlier by an order dated January 5, 2024, whereby a coordinate bench rejected his earlier bail application being CRM (DB) 2 of 2024. Paragraph. The petitioner says that the charge of murder does not lie against him. Stop. There was a quarrel between him and his elder brother pertaining to their father's property. Stop. In the heat of the moment, comma, the petitioner dealt a blow on his elder brother, which caused his death. Stop. He had no intention of killing his brother. Stop. There was no premeditated plan on his part to cause any harm to his elder brother. Paragraph. Learned advocate for the state produces the case diary and draws our attention to the relevant material therein. Stop. She shows us the postmortem report. Stop.
Number 131, my lord, the case.
She's
Comment. Remarks. Date was due to.
That was due to cutting of air tube by sharp weapon.
The report says that the death of the victim was due to cutting of air tube by sharp
Weapon. That is a
sharp
finding.
cutting instrument. Stop. The offending weapon, comma, being a dagger, was recovered from the closet of the petitioner. Stop. The paragraph. We are told that the trial is in progress. Stop. The progress is satisfactory. Stop. 7 out of
23.
23 witnesses have been examined already. Stop. Paragraph. On an overall assessment of the material on record and the gravity of the alleged offense, and in view of the prima facie incriminating material against the petitioner, comma, we are not inclined to allow the petitioner's prayer for bail at this stage. Stop. Paragraph.
But kindly expedite the trial without any time limit.
Paragraph. However, comma, since the petitioner has been in custody for
12 months, 13 days.
for 1 year and 13 days, comma, we request the learned trial court to expedite the trial to the extent the business of the court may permit. Yes, yes. Huh? Reject, dispose of, yeah. Yes, Mr. Gomes.
That those two has not
Then not today.
The petitioner.
Who is the petitioner?
Not happening for the petitioner.
Then CD has not come. 29, not today. Which is in next
Matters will not be taken up today.
after 1:30. We'll rise at 1:30. We'll come back at 2:15. If you are there, if you want to do the matters. No, we'll go serially. Next koto, Dakun?
43. May please, your lordship. Lord, this is a renewal.
Yes.
Well, these two petitioners are in custody for 3 years. Till date, charge has not been framed. So, my lord, witness action could not start.
My lord, I have not with the CD.
You have?
I have not with the CD.
Oh, not today.
Whatever Passover, whatever. Passover.
Passover. Will you come after 2 o'clock? We will come. Will you come?
The difficulty is we cannot go against the bar even if we wish to.
Not today.
34, Lordship.
34.
34, a prosecution case is under section 498A, 326A, 307 and 506 of the IPC. My lord, investigation has been completed, charge sheet has been submitted. Charge sheet has been submitted.
Yes.
Investigation has been completed, charge sheet has been submitted. My lord,
You are the sole accused.
I am the sole, no,
Husband.
husband, not sole accused. Father and mother also, they are enlarged on anticipatory bail. Main only.
What is the injury report?
Yes,
My lord, injury report, my lord, incident took place on 10th January. The victim went to the medical on 12th, my lord, almost 35 hours. My lord, doctor found 1% acid injury.
1% burn.
1% acid burn injury.
Acid throwing by husband over right hand.
Yes, my lord.
Carbolic acid. His chest.
I have given 164 of the victim lady, Lordship.
Yeah, acid throwing is very serious matter right now.
My lord, acid,
Should
my
not
lord,
be sold in open markets.
Yes.
my lord,
The law.
my lord, 35 hours, after 35 hours, 1% injury. Can it be believable?
We are not.
If it is, my lord, kindly have a look to the seizure list, my lord. My lord, kindly have a look to the seizure list. My lord, this is carbolic acid. The police said, medical, my lord, it is sent to the laboratory test. Report has not yet come.
Whatever the acid be, what kind of?
My lord.
The act of throwing acid at your wife.
This is not-
Carbolic or
my lord, this is phenol. My lord,
প্লিজ আমাকে অ্যাসিড খাওয়াতে যায় আমি সরিয়ে নিলে আমার ডানাতে পড়ে গেছে
my lord, my lord, carbolic acid is a, my lord, it is almost a granule. It cannot drop.
very well.
My,
Issue.
my lord, kindly, I mean, custody, my lord, 151 days.
That is nothing. Yeshu. The petitioner prays for bail. Stop. He says that he is in custody for
151 days.
151 days. Stop. Paragraph. The petitioner says that he had no intention of harming his wife. Stop. It was more of an accident. Stop. Stop. That there is no such incriminating evidence against him as would justify his continued detention even after completion of investigation and filing of charge sheet. Charge sheet has been filed. Paragraph. Learned advocate for the state produces the case diary and draws our attention to the relevant material therein. In particular, we have seen the
164
statement of the victim wife recorded under section 164 CRPC, as also the injury report. The wife categorically, the victim lady categorically states that the petitioner tried to pour acid into her mouth. When she fought and withdrew herself, some acid fell on her hand, causing injury. Paragraph on an overall consideration of the facts and circumstances of the case and finding prima facie incriminating evidence against the petitioner, and given the conduct of the petitioner, heinous conduct, we are not inclined to extend the privilege of bail to the petitioner, at this stage.
One technical reason why learned friend.
One
Technical fault he has done. He was arrested on 13 January 2024.
Yes.
So from 13 January 2024, today is precisely 216 days. He said 251. Yes.
No. 151 days.
He says 151. Rejected.
Obliged.
Mr. Rana Mukherjee is here? No. Can we go for our lunch now? We'll come back at 2:15 in case you want to do your case, but we have to come back once. দেখে যান।
আর তোমার 34, 35, 36, 37, 38, 39, 40, 41, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54.
53, my lord.
Yes, 53.
My lord, application for bail, the charges under section 363.
All very well. Where's your other side?
No, there is no other side.
So should we take it up in the absence of your other
No,
side?
no,
No?
no.
Then why are you starting? Not today.
Much.
কি? না না, ফার্স্ট কল হলো তো। টেকনিক্যালি পারফেক্ট থাকুন, সেকেন্ড কল করুন।
Second call.
তুমি পরে এসো, নিজে কাজ করো।
35, 36, 37, 38, 39, 40, 41, 42, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54,